All right, we're going to go ahead and get started. And I was just looking at the chat box. We have lots of folks calling in from Canada, some from London. Really exciting. Looks like we have a great group today. So just a few housekeeping items before we get started. Everyone is in listen-only mode. So there's two ways to communicate with our panelists today. First is through the chat window, which hopefully you found that and see lots of people sharing where they're calling in from today. So thank you for that. There's also a separate Q&A panel that you can also use to submit questions that you have. We did get some questions before the webinar this afternoon, so we will be addressing those throughout today's session. So thanks for anyone who has shared questions ahead of time. So without further ado, we're going to go ahead and get started with our introductions. Again, my name is Raymond Lee, and I'm the CEO of Careerminds. We're a virtual outplacement company and the sponsor of today's event. And I'm also joined by my co-presenter, Garrett Kennedy, who's a partner with DLA Piper. Garrett has litigation experience, including defense of claims of gender, race, national origin discrimination, sexual harassment, and retaliation, as well as claims brought pursuant to the Fair Labor Standards Act and state and local wage and hour laws. And Garrett is based in New York.
Thanks, Raymond. It's nice to be here with you.
Yeah, thanks, Garrett. Garrett's been on a couple of webinars with us, and he's going to be sharing some of his legal expertise when it comes to layoffs. So I'm going to go ahead and kick things off, and then toward the end when we get into the legal review. And Garrett, along the way, if we have questions around, some of the legal things that we're going to be talking about this afternoon, we'll try to make this as conversational as possible.
Sounds good to me.
So over the last several months, we all recognize that our organizations have been faced with significant opportunities to manage costs. I've seen companies have implemented significant furloughs. Companies have had salary reductions, some voluntary retirements, voluntary layoffs, all ways to avoid the need for an involuntary reduction in force. It's not something that we look forward to. And we also recognize that layoffs are incredibly impactful to our culture, not just the employees who are exiting the company, but also employees who are retained. And so it's not something that we take lightly. Whenever there's a layoff, there's always risk involved. And today's session, we're going to be focusing much of our attention toward implementing a virtual reduction in force. But I think it's really important to recognize that as your layoffs become larger in size, whether it's 5 employees or 5,000 employees, there's a specific amount of risk that you're taking. And I grew up in HR, worked in HR for 15 or so years before launching Careerminds. And during the 2000 dot-com bust and also the financial crisis in 2008, there were massive layoffs that occurred. And us as HR professionals, we oftentimes rely on our RIF playbook. And when I think back during those two reductions in force, they're very different than what we're experiencing today. Much of the workforce was in an office somewhere. There were, the layoffs were primarily done face-to-face. And, since just a few months ago, the need to do layoffs is not the same as it was a decade or 2 decades ago. And so it's almost like we're reinventing our playbook in terms of how we as HR have to implement a virtual reduction in force. So I'm going to assume up to this point, for those who are on today's session and possibly are faced with, having to continue managing costs and implement a voluntary or involuntary reduction in force, this generally starts with some business case for the RIF. And it's really important that leaders of the organization, managers really understand what that business case is for any upcoming reductions in force. We're going to talk about how this business case is communicated to employees virtually when they're impacted by a reduction in force. But generally speaking, this is something that you're going to be working with your team in terms of, understanding and defining what that business case is and how, the organization communicates that consistently throughout all of the meetings that are occurring, whether it's a one-on-one meeting or a group meeting. So one of the first and foremost, one of the things you want to avoid is a virtual group meeting. And there's been a lot of negative press out there of some companies who early on were doing group layoffs through Zoom meetings. And this is something that I would definitely recommend avoiding. And we'll talk a little bit later about a virtual webinar, kind of like what we have here versus the meeting. But in a virtual group meeting, and by the way, the faces that you see here, this is just a screenshot that we took from the internet. So this isn't an actual, you can just kind of look at, the faces here, everyone's smiling. And but the point of the matter is you don't want to do a layoff with a virtual group where you're having people sign on in a meeting. Some are activating their camera, some are not. It's really not personal to the employee. And in most cases, it's unexpected. The other thing that happens in this particular case is that, if you don't launch the meeting appropriately, you'll have people actually showing up to the meeting after the meeting has already started. The other thing is you can't manage the emotions and the mute buttons and the responses that you may have from a group. So it's certainly, we're going to talk about other options for a potential group layoff meeting through the use of a webinar, but doing a virtual group is definitely not recommended. So the one-to-one virtual RIF meeting is really our recommendation. It's very similar to when you're on site somewhere and in your office. If you're going to do a large-scale reduction in force, generally speaking, you're going to have in that room, you're going to have the manager who's delivering the message, you're going to have the employee who's impacted, and you're going to have someone from HR serve as a witness. They'll also review the severance package, outplacement services, other things that are related to severance. The benefit of a one-on-one meeting, as you know, if it's face-to-face, you're maintaining confidentiality. And you're giving that employee, the opportunity to hear the message direct and even respond and ask questions. Now, one of the questions that we received prior to today's session, there was a few people that said, should you require everyone to share their video? And I think that it's just my response to that, my answer to that is that it really depends on your company culture. In most cases, I'm finding that you want to give employees the option. So if they sign in, they don't necessarily have to share their camera. HR could just be listening in. They don't have to share their camera. I do think that the manager sharing their video and the employee, hearing and seeing the message that their job's impacted, live from the manager, I think that's really important. But I think you can give employees the option whether they want to share their camera or not. So there's been a lot of talk about the Zoom security. And in this particular example, we're going to use Zoom as an example. Later in the session, we'll go through some of the kind of best practices. And certainly if you're using other platforms like WebEx, GoToMeeting, maybe you're using Microsoft product or Google, there's obviously lots of ways that you can set up a meeting. But for the purposes of today's session, many of our clients and organizations are using Zoom today to host their regular meetings. In the setup, there are several functions that you can enable. So one of the things that you really want to consider is if you're doing back-to-back meetings, one-on-one meetings, you want to enable the waiting room option so that if you're delivering a reduction in force meeting, a notification meeting with an employee. Let's say that employee has lots of questions and it runs over the 30 minutes that you have allotted for that meeting. You want to enable the waiting room and lock that meeting so that whoever's scheduled to come into the Zoom meeting next isn't going to join the meeting when a notification is already going on. And so if you enable that, essentially when that employee arrives to their meeting, they're just going to see that there's the host is already in a meeting and that they're going to let you in soon. So it's almost like if you're in an office, there's a waiting room right outside the door potentially, so that you're not able to walk in to an office when there's a meeting already going on. So I'm just kind of looking at the chat box here and I see that someone's asking a question about how do you set up a meeting without causing suspicion? Seems pretty obvious if you don't set up a meeting. If you set up a meeting with the boss, HR, and employee, do all meetings in one day. So we're going to cover that. It's a really great question about the idea of how to set that meeting up, and even to the extent of not necessarily literally giving people a heads up as to what's going to happen. So I am going to touch on that in just a bit, so appreciate the question. The last thing that I'll share is in the meeting, you can remove a participant from the meeting by right-clicking up where their logo is, and you can actually remove someone so that once you remove them, they're not able to re-enter back into the meeting. So again, every platform's different. In Zoom, if you're going to be doing back-to-back meetings every half hour with employees, you really want to be aware of how people are coming in and leaving the meeting. If you're using your account in HR, you have one account, that account URL address is the same meeting. So you literally will have people coming in and leaving that meeting room using the same URL. So again, it's really important that when people leave, they're not able to come back into the meeting, as well as people are coming in, someone can't come in following them until that meeting is actually over with. So this gets into some of the pre-communication thoughts. So, right now everyone's working virtually, and it's just interesting because if you think about the home right now, employees are home with their kids. Now, in most cases, school's done. So you're now in summer school, in the summer, and some kids aren't allowed to do summer camp. So the kids are still home, spouses are still home working virtually. And there may be parents that you're taking care of, or other, there's pets and other things going on in the house. It's incredibly stressful. And so the idea of scheduling a meeting and the employee coming to the meeting just thinking that it's just a routine meeting, and then you're communicating to them that their job's being eliminated, you have to really give thought around what's going on at the home. And this idea of pre-communication could be effective in letting employees know either the day before or possibly 2 days before that some changes are coming. And I think that if you try to be as vague as you can, but you also don't want to say whether or not they've been impacted. So for example, let's just say in your company, your CEO sends out a letter or sends out some communication to all employees and says, over the next few days, we're going to be hosting some meetings as a result of COVID-19 or other factors that are going on in the economy. The company is going to have to make some changes. Some employees will be impacted, and there will be a series of meetings that are going to go on over the next couple of days. And so you're sort of giving people a heads up that there are meetings that are taking place. And the other thing is that employees prior to their meeting will get into a safe place. So if they know they're meeting with their manager to determine the outcome of this potential reduction in force, they're likely to go into a quiet room and kind of remove themselves from their family situation to understand what that impact is to them. So, my belief is trying to be as transparent as you can up front, I think is important to set some expectation. Garrett and I, as we were planning for our session today, we talked about how transparent do you want to be? And I reflected on that quite a bit. And I really think it depends on the culture of the company and how much information do you want to share with your employees. Garrett, did you want to provide any other context just around what you're seeing with your clients around that?
Yeah, I mean, I think the one thing that I would add is part of the consideration of culture is also what is the nature of the business and who are the people being affected as part of the business. If you have individuals who have access to highly confidential information, customer contact or client contacts or vendor contacts, does it suit your business interest to let them know 2 weeks in advance or a week in advance that they may be impacted? And do you want to have people who have access to highly sensitive information, working at your offices or remotely and having access to your systems with the knowledge that they may be terminated? I mean, it may present some real risk to your own proprietary information. So I think you need to balance that. And that's really, I think, one of the big factors you need to think about as you move through this process. And likewise, think about what the senior level of the position is, right? Because it may be one impact if you're letting go of the mailroom guy, and another if it's a senior executive, and certainly other people are going to feel that filter down too. So I think you just need to be mindful about looking at it holistically. And while you want to be humane to your staff, I think you also need to make sure that you're protecting your interests at the same time too.
Yeah, that's a really good point. I had a question that came in that, do you really think HR should send out the meeting invite? I think that it's a really good point. I think the managers, it just depends on the situation. I think it also depends on the size of your company. I think the managers could send out the invite. You could actually, when you send out the invite, you can obviously, if it's a group of people, you can do a BCC, but even in Gmail, you can select private so that if you're sending out a group email, it's not going to show other people who are copied. I think you could go either way on that particular one.
And I think that's one of those situations where you really just need to use your best judgment as to your culture, the size of the group affected, and really how much you want to message there. I think that's a bit of a judgment call.
Yeah. I have another question here. A relative with 40 years of service got a phone call telling her she was being laid off and that her severance agreement and other materials be sent via email. No one explained what was in the agreement or what was being sent. So it's more of a statement, I think, here. And one of the legal watchouts that we were gonna talk about later in the session is emailing the severance. I mean, that's certainly okay to do, but when you're on a call with someone, especially 40 years of service, and they're being let go, you certainly want someone on that witnessing the questions, the responses, what the manager actually says, but then giving the employee the space where they can hear about what severance they're getting and what other outplacement services, other severance benefits that are going to pertain to them.
And I think from just an employer's perspective, I think it's in your best interest to have somebody explain what's in the benefits package to somebody who's getting it. I think it's going to make them more likely to sign it. If you don't do that, they're probably going to have to go talk to somebody else to get information about what's in the package, and that may create other issues for you. So I certainly think it's not only best practices, but I think it encourages actually resolving the issue.
Yep, that's a great point, Garrett. And we got another question here about if you don't have a group meeting, won't the word start to spread via employee to employee who have had meetings earlier in that day. And it's a good transition because we're going to touch on pros and cons of a webinar layoff. And so before we jump into that, I think that whether you're virtual or in an office, if I'm in a department and I'm notified at 9 o'clock in the morning, and I know that other people are having meetings later in that day and I'm impacted, I could easily text my coworkers and say, hey, I was just riffed and I'm leaving the facility as we speak, or I'm being escorted out of the facility. So I think you're going to have people spread, kind of spread the word. I think it's also important if your CEO or business leader is sending out some pre-communication that meetings will happen over the next day or two. I think it's important to stress that meetings are very confidential. You shouldn't post things to social media. You have to think about the employee's brand. If you post something out there and it's tied to your social media account, that could have a negative impact on the employee. And so sharing, whether it's through text or calling, I think you really want to try to avoid that. But it's a really good point, because I think based on the size of the layoff, we've recently read online of companies, and I don't want to name companies for the sake of our session today, but there's obviously been lots of reports of companies who have had to lay off in the thousands and thousands of people, several thousand people at one time, globally, all over the country, all over the world. And the question becomes, how do we do that in a swift manner? How do you have 3,500 meetings over the course of 1 or 2 days? And I'm not opposed to hosting a webinar, and the webinar is confidential. So employees who are attending the webinar can't see anyone else, just like we're in our session today. We have several hundred people on today. No one can see who else is on unless you chat something and someone can, see what you chat in. But you can obviously turn that off. But in a virtual webinar situation, you may have an employee who videotapes the webinar. You could be videotaping me right now and then post it to social media. So you have a little bit more risk in controlling what happens as your employees are watching the webinar. Are they recording it? Are they sharing it? And in the case that I was speaking about, an employee did record the whole meeting and posted it online. Now, Garrett and I talked about this quite a bit and sort of debated it at length. And I think, Garrett, your comment was, if you're going to do a group webinar, you really should consider the group size. You should consider the level of employee. It's not recommended that you just do a company-wide layoff from your C-suite down to your hourly employees. When you think about, I worked in manufacturing most of my career, and it wasn't uncommon in a facility, we would bring in, the union workers or hourly employees. Many times the layoffs were done by seniority. In other industries may have a similar situation where groups are appropriate. But when you're thinking about managers, directors, and even executives, I think, depending on the level of employee and their job and the scope of their position, and maybe even tenure with the company, you may want to consider meeting with them one-on-one and giving them that opportunity to meet one-on-one. So our recommendation is, if you're going to do a group webinar, definitely go down the path of a webinar versus the meeting where everyone can see everyone, and consider maybe smaller groups by department versus company-wide. Garrett, any additional thoughts to the webinar?
Yeah, I mean, two thoughts. If you're going to do a one-on-one, and this just goes back to the question that you were answering earlier, if you're organizing it, just know who you're organizing it with. Don't start with the office gossip. Put him or her, near the end of the list. I would suggest that, you ask people to, kind of keep it confidential, because you want to have these discussions with other people. But do be careful of, being a little too heavy-handed with that, because you don't necessarily want to run afoul of any potential NLRA, kind of collective action rights that employees may have to speak about their employee compensation or similar protected activities. So I think you want to be careful there. And I just wanted to note there's a question that is pending. In a virtual layoff, there's also a chance of employee recording the conversation. How do we avoid that? The answer simply is you can't avoid that. People are going to do it in this day and age. Somebody can sit home with their cell phone on and record it. You have to proceed assuming that they are going to record it. So I think you should be prepared to have a good script, know what you're going to say, make sure it's vetted, and be very careful about what you say, and make sure that whoever is giving this presentation is somebody who presents well, is capable on their feet, and if you're going to have any question and answer or anything like that, that they are very able to handle that without, let's say, putting their foot in their mouth.
Yeah, that's a really good point. I'm glad that question was asked, because when you're in an office, obviously, an employee's not going to walk into an office, sit down and put their cell phone on the table and hit record. But when they're sitting at home, and I think you're more likely to have someone record in a webinar session. But you're right, Garrett. I mean, you could essentially be on a one-on-one, and they could have their speakerphone on, and then they could literally just have their phone sitting there, hit record, and are recording the conversation. And I think that's right. I mean, you have to assume that everyone's recording it. Whether or not they're going to use that at some point down the road, I don't know even if they can. I mean, can they do that? I don't know.
I mean, it would probably depend on what state you're in, but a lot of states have one-party consent, so it's certainly not, inherently problematic to do that in a lot of those states. So they could surreptitiously record it. And just speaking from experience, even before we were having to do this with webinars and doing it face-to-face, I've had more than enough instances where clients have said that they had employees come in and clearly were attempting to record meetings with HR or things like that. So I would assume that that is even more heightened now in the webinar world.
Right. Should, Donna's posting a question here, should the employer record the meeting?
I would generally say, no, you shouldn't. First, I don't want to run afoul of any potential local state laws regarding recording somebody without their consent. And given that it would be over a computer, there might also be, as I think about it, wiretapping issues or something along those lines. Setting that aside, I think it just becomes an uncomfortable situation, because if you want to ask the employee if they're okay recording it from the outset, I think it's just going to set everything off in a really bad way. And frankly, I don't know what benefit there really comes out of it. That's why you have a witness there, and that's why you try and proceed that way.
Great, that's a good answer. So the person who asked the question here about doing the group meeting and then doing one-on-ones after, I think that's a good idea, and it's one that's pointed out here. Consider one-on-one follow-ups after your group webinar. And so if you're doing the group, you basically are letting people know the business rationale and that they're being impacted. And then you can say, following this meeting, you'll receive a call from HR to go through your severance and answer any questions. So that's certainly a good practice, so that you don't, the meeting's not prolonged. But I think it's important that if you're going to do those follow-ups, you should follow up quickly after that meeting and not have the employee wait a week or so to receive information on their severance.
You should also expect the employee to potentially not take your call, particularly in the web-based telework environment. I mean, they may simply just not answer that call. So don't feel like you can compel them or force them to do it after they've already been separated.
Yeah, so that's a really good point. So the next the next slide here, actually a couple slides, we talk about the schedule and then also sending out a meeting invitation. If you're sending out that meeting invitation, I think it's important in the meeting invite, I wouldn't put the title of the meeting, RIF meeting or or RIF notification meeting or term meeting, I would use things like check-in meeting, follow-up meeting, or something like that, because if an employee has their calendar and it's visible by others and it's not locked or hidden, they can see, you know, meetings on their calendar, or maybe even assistants and so forth that have access to people's calendars. So if your managers are setting up meetings ahead of time, I would definitely recommend using a subject line that's vague, and then also confirming that they respond, that they confirm that that time is actually good for them. So some of this is kind of redundant here. In terms of just overall planning for the notification meeting, again, timing and pre-communication needs to be determined. We didn't talk too much about the length of the meeting. When you're in person, generally speaking, these meetings go fairly quick. You know, usually it's 15 minutes. It can stretch beyond that depending on the amount of time that you give to the employee to ask questions about the severance, so that length, generally speaking, is 30 to 45 minutes usually. We talked about the platform, so you may have your own platform internally. Definitely use that. And we're going to touch a little bit more on the severance package, but just like you would be doing an on-site reduction in force, having those severance packages compiled and pulled together ahead of time, so that once the notification meeting's complete, you can email them those severance packages afterwards. And then last, practice, practice, practice. For some managers who have, through, you know, their entire career, they've never done a Zoom meeting and they've always been in the office and relied on meeting face-to-face in the office in conference rooms. And then now all of a sudden you're asking them to launch a kind of a virtual notification, and you're asking them to present their video over a Zoom or a WebEx interface. It's something that I would recommend you want to practice with your managers. Have them actually come into the meeting, practice their script, navigate around. You definitely don't want a manager to enter in the meeting and can't figure out how to unmute themselves, or their video's not coming on. There's a whole host of things that, as you know, we all experience when we join meetings. Someone's speaking and they're on mute, and that's just part of the practice part of it. I mean, you don't want to join into a meeting and have issues, because it just makes everyone very uncomfortable. So if you're thinking about doing pre-communication and letting people know ahead of time that they're going to have a meeting to determine the impact, and it's a large-scale layoff, having a schedule that your managers work off of will keep things organized. So if you're supporting a group or an organization and there's multiple layoffs happening, definitely would recommend putting a schedule together with your manager, and also having a note section. So for each of your notifications, you want to collect notes, questions that come out of that meeting. So you also have a column for questions that come up, or even issues. Maybe the employee said something or shared something, and if you're doing 10 or 50 or 100 of these notifications over the course of a couple of days, you want to get those questions from individuals. This is one of the challenges that you may have with employees in a group meeting. If you do a big group of 50 over a webinar, if you're not following up with those employees shortly after to check in with them, you really don't have a sense of where people are in their mind. Versus if you meet with them one-on-one, you deliver the message, you give them the opportunity to respond, and then you share with them their severance and career transition or outplacement services. You can really understand how this is impacting your employees throughout the reduction in force. And so having a schedule, I think, is going to keep you organized and also keep you on track with how things are going with your reduction. So I want to get into just a couple of tactical things around the actual notification meeting. When you think about a virtual notification, it's very similar to the structure if you were going to be meeting with a person face to face. The manager comes, you're in the virtual meeting. HR is either listening in, they may have their video on, but the manager begins with the reason for the decision. They're going to be very brief. We'll show you an example in the next slide as to why this person's being impacted. What's the business case? You wait a couple of seconds, you listen for any feedback from the person, and then you respond accordingly. It's important to just give that person the opportunity to react, and we'll share an example of a reaction, and then also we'll give a sample response. And then from there, you're transitioning over to the HR rep going through their severance package at a high level. If you're having employees sign a release or a waiver, you don't want to read through the entire waiver, but hitting the highlights on key dates, when's your last day of employment, things of that nature are important. And then reviewing career transition or outplacement services that the employee is going to be getting. That is really the transition to either back to the manager or you're closing out the meeting. Now, one of the questions came earlier on around, does the manager stay in the Zoom meeting with the HR person and the employee as they're going through the severance benefits? I think it really just depends on your culture and if you want the manager to be part of that. And if they are, then you can transition back to the manager who can kind of cover some of those work transition things that maybe need to be discussed. If the employee does have things back at the office that they're going to need to get to, maybe you're in a state right now where employees can't go back to the office just yet, so you'll have to coordinate that down the road at some point. So you'll have some flexibility, I think, in terms of how long the manager stays in and whether or not they stay in for the whole meeting. If this is your first time doing it or it's been a while, this is an example of a message, and it's very generic, but it's short and sweet. You don't want to get into a situation where the manager starts rambling on around why the person's being impacted, making it personal, related to performance. So this example is, due to budgetary requirements, a decision's been made to reduce staff. You're amongst those affected. Today will be your last day of work. You could also weave in things around, due to COVID-19 and cost-cutting measures, a decision's been made by the company and our leadership team to reduce staff. Your position is being one of those affected. Today will be your last day of employment. Friday will be your last day of employment. So you can edit this in a way that really delivers the message of why this person's being impacted. You don't want it to tie to their performance. They will probably respond with some questions. They may, if it's a surprise and you don't give anyone sort of a heads up and they didn't see it coming, they may not have any questions. They may just be quiet and surprised. They may say, how am I going to take care of myself? How am I going to pay my bills? You briefly pause and say, that you're surprised by I see you're surprised by the news, and I can hear your concern about finances. The company will provide severance and outplacement services to help with your transition. Let me share the details. And so while you're on this virtual meeting, if employees are asking questions, HR needs to think about transitioning the conversation to discussing severance and outplacement, getting the employee to think about the next opportunity. If they're asking questions about, is this due to performance? Who else is being impacted? There's a whole host of questions that your managers may get. It really is HR's role to kind of step in and help drive the conversation to moving toward reviewing the severance and outplacement services program. So there are some few frequently asked questions that we've supplied at the end of the presentation that we're going to share with everyone. So you'll see those, some other questions, but it's just important that you give the employee the opportunity to respond and comment. Garrett, did you have any comments in general about sort of the meeting and the message?
Yeah, I think the one thing I would just say about the messages is that I do think it's you don't necessarily need to give the full the full thought process that you've put behind everything and the deep analysis of why somebody is selected versus somebody else. But I do think that you should provide a explanation as to selection, whether it be simply business needs, lines of businesses are being eliminated, whatever the case may be. And you need to be truthful about it too, just from a legal perspective. If somebody later asserts a claim that they were terminated due to a protected class, there are certain jurisdictions that will say, if you gave a false reason for somebody's termination, that itself might be sufficient basis to allow a claim to at least slip all the way through trial. So it's something to think about as you go through it. So do be truthful, and also recognize that people do start asking questions about why me versus somebody else, or why wasn't why was somebody else selected, not me. You don't have an obligation to tell them why somebody else was selected, and frankly, I would generally encourage against doing that, because that's somebody else's private information. You don't want to really be going there, and that's only going to increase the risk to you. So I certainly would just be a little bit discerning in what information you provide, but I would make sure you're truthful in whatever you give.
Great. I'm just looking at, as you're answering here, Garrett, I was looking at some of the questions that are coming in. If you can, make a note on your legal section when you're talking about severance. Someone asked about just any observations around how severance has evolved in general, just some observations. There's a question here about what about people not affected, best practices to support these employees. This is a really good point, Kate. There's definitely survivor guilt that exists. So when you have a large scale layoff, and let's say half the department is let go and the other half of the department remains, that's where I was getting at with that first quote by Southwest Airlines. Layoffs are very impactful, not just for employees who are let go, but they're also impactful for the survivors. There's a period of time after the layoff that employees are feeling guilty that some of their coworkers were impacted and they weren't impacted. So there's certainly training that you can provide to your managers, your surviving workforce, and really kind of discussing things around resilience, change management. A lot of the emotions that employees that are feeling internally who aren't impacted, they're completely normal. You have to think through, you have to work through those. So there's definitely, training that you could bring in to do that. Our company provides that kind of survivor training to managers so that they can best communicate with their employees, address issues that are coming up, because you certainly want those employees who aren't impacted to embrace the new direction and embrace the future so that people are engaged and productive. So I'm gonna hop back in here, and we'll hop back to the questions in a little bit. I see that there are a few other questions that we'll get to toward the end. There's obviously going to be a lot of emotions that come up, and I won't go through this in detail here. You will get a copy of this in the follow-up materials, but just recognize that employees will respond with a variety of different emotions. Most of the time, it's either anger, hostility, or grief and sadness. And some people are just going to be quiet. If you have an employee who is angry and hostile, and they're kind of argumentative and asking, why me? Why was I selected? It's really important that your manager stays calm. They don't argue. They don't become defensive. And that you just let them vent for a little bit, and then you move to transition them to reviewing that severance document. If someone starts crying, which is common, give them the opportunity, give them the space to grieve and share some tears for a little bit. You want to give them that space, but then at some point you're going to have to say we have a transition package, we have a severance package that we'd like to go over. So I would recommend reviewing this with your managers as they're prepping for the meeting, because being prepared and recognizing that people will have some kind of reaction. And oftentimes the reaction that you're expecting your employees to have isn't what they're going to have. And so be ready for that. So just recapping a checklist here, you may consider having someone in HR serve as sort of your command central. I think of the days when we've had, on-site large-scale RIFs. We've always had someone in HR who is in the HRIS system managing a spreadsheet, and they're literally getting calls from the managers who are doing the notifications and recording that the meeting happened. Were there any issues? And also any frequently asked questions that are coming out of those meetings that you can send to notified employees later of questions that you want to respond to. So consider that. The other thing today, more important than ever before, is getting an updated email address. Employees tend to have 3 or 4 different email accounts that they're using, and you're most likely going to be emailing the severance package right after that meeting. So you want to make sure you get that updated email address and phone number. If you're having an employee who is exiting right after that meeting, you certainly want to give IT a heads up, maybe even security if employees have badge access. So just be thinking about that. And last here, we talked about this, coordinating a time to retrieve personal items. It's a little bit tricky right now because of the limitation that employees may have in returning back to work for that. So you'll have to coordinate with with your HR team and managers for that. Garrett, you want to run through your legal checklist and then we'll wrap up?
Certainly, thanks, Raymond. So just from a high level, these are a few, let's say, factors you want to think about anytime you have a reduction in force going on, or even generally any employee termination. The first real factor is you should make sure that you justify your business rationale for separating someone. You want to make sure that you have a consistent reason, and the reason for that is, there's a few of them, but principally, you want to avoid the situation where you could be seen as cherry picking certain people and you later have a potential claim that you've maybe selected people based on their protected characteristics. This may be easiest if you're, say, eliminating an entire department. That's a pretty straightforward justification, but it becomes a little trickier when you're eliminating people based strictly on performance-related rationales or things like that. So before you start laying people off, make sure that you have a consistent and legally legitimate basis for letting people go. Once you've identified the people you would like to let go, make sure you look at their employment agreements and offer letters and any company policies that may come into play. You're going to want to look to see if anybody has any notice periods, if they're employed for a term, if they're entitled to any severance, if they're terminated without cause, or any other considerations that may play into compensation that they'll be due on their separation, upon their separation, or that otherwise might limit your ability to terminate them at will. Having done that, we certainly encourage you whenever you have a large RIF to look at any potential disparate impact issues, namely do an adverse impact analysis to see whether or not any particular protected characteristic or minority group is disparately impacted by the employment decisions that are being made. Assuming that that is not the case, I would also look to see if there are any other particular risk factors surrounding the people being terminated. Have they made any internal complaints? Are there any other just particular red flags relating to the individuals impacted? As you start preparing for the RIF, you need to look at whether or not any state or federal WARN Act protections will be affected. For those of you who aren't familiar with the WARN Act is there's a federal WARN Act which requires that employers must give at least 60 days advance notice where employees are being terminated as part of a group termination or mass layoff. And there is a bit of a complicated analysis that it goes into this. So I certainly encourage you to speak with your counsel as you go into this and determine whether or not the WARN Act applies. But as a back rule, but as a rule of thumb, for federal WARN, you need to have at least 50 people being affected at what's called a single site of business. Although again, there are some kind of legal complications around what is a single site. So make sure you talk to your attorney. And there are also federal state WARN acts as well that may have more employee-friendly terms. So for instance, New York, that 50-person threshold drops down to 25, and it's a 90-day notice period. So you're going to need to be compliant with both state and federal WARN acts. One thing that we've seen, and you may have heard of in the COVID sphere, is what's known as the unforeseeable business circumstances exception to the WARN Act. Basically, this exception says that while you're typically required to provide 60 days notice, where business circumstances are unforeseeable, you may shorten that notice period. Now, a lot of employers have relied on this in the COVID era, but I certainly think I would be remiss to say, if I were to say that now 3-4 months into this COVID era, that it is still unforeseeable that it's going to be impacting your business. Now, it may still be a viable defense, but I think you need to not be putting off layoffs or not be putting off giving notice of layoffs or terminations merely because of COVID at this point, and assume you'll be able to rely on that exception. And it's also worth noting that it does not exempt you from the WARN Act. You still have to give notice. You just may not have to give as much. And some state laws may not recognize it. So make sure that if there is a applicable state law, that it recognizes that exception if you intend to rely on it. Severance is a big question here. Some employers offer it, some don't. Certainly, if you offer it, you're going to want to make sure that you get a release from employees in consideration for it. Recognizing the challenges, though, that are facing a lot of employers right now. Many employers are opting not to offer severance right now, or if they are not necessarily lucrative severance offers. I think you need to think about the benefits of offering severance. You are not required to, unless it's in an employment agreement or you have a company severance plan that's applicable. But if you do, make sure first that you work with your counsel to develop an appropriate severance and release agreement. And you're going to have to consider a few factors, such as wherever you have a group termination where severance is offered, the Older Workers Benefit Protection Act comes into play. And this has a few specific requirements that you're going to need to comply with. This includes you must provide workers who are 40 years or over at least 45 days to consider their release when it's a group termination. They also get 7 days after their release after they sign their release to revoke it if they so choose. And you also have to provide them with information regarding who was and was not selected as part of their termination. That information includes basically title and age of people selected and not selected as part of the termination. So that's just one other consideration you have to have in play where you have a group termination. And again, work with your counsel on this because there are some nuances to it. Lastly, think about PTO. Do you have to pay that out upon termination? Look at your policies. Some states have different laws on whether or not you have to pay that out, but be mindful of whether you need to pay out accrued but unused PTO. And I would just note that certain states, and in particular California, if you put people on if you furlough them or put them on layoff, you may be obligated to pay their PTO at the time that you do that, notwithstanding that they are still technically employees. So just make sure you think about PTO and any other similar types of benefits that need to be paid out. And I know I ran through that quickly for time.
No, it was perfect. It was perfect, Garrett. And while you were going through that severance question, I saw 1 or 2 questions around, well, the one person asked observations about how severances have changed or evolved. Someone says, what if we can't afford to offer severance? I mean, is it safe to say that if the more severance and support you provide, is that correlated to, I mean, I know this is an anecdotal comment. I'm sure this is an anecdotal response unless you have data that suggests this, but is it the more severance you provide to an employee or the more generous you are, is it less likely that the employee is going to retaliate, or if you get them to sign a waiver and you provide a nice severance benefit, that they're not going to come back and sue you for some discriminatory reason? What are your thoughts on that? Is there a risk of not saying, oh, we don't have a budget, and you don't do anything, and then all of a sudden you have 3 lawsuits on your hands, which is going to cost the company?
Yeah, I mean, look, there's no silver bullet to avoiding a lawsuit, and certainly you can offer somebody, ample severance, and they still come back and ask for more. They threaten to sue you, and there's nothing to protect you from that. I think that certainly the more you offer people, the more likely they are to sign it. But I do also think that if you realize there are high risk factors you need to consider, you just recognize that if you say I have one particularly problematic employee or who's a high risk employee, you may be setting a negotiation floor for yourself that's higher than you'd want to if you offer them a lot of severance from the outset. But I think you just need to use your best judgment there. And certainly I've seen a broad range of severance offers during the current pandemic. Some people offering none, some being relatively generous. I think you just need to look at your business situation to see what you can do, and to talk to your attorneys to see what the real risk is around the separations that you're talking about.
Great. I appreciate that. And so as we wrap up, if you are faced with a situation where you're having to implement a virtual reduction in force, one of the things that we're going to be sending is, along with a copy of the recording, as well as today's presentation, is we'll also provide you with a link to a layoff guide, a virtual layoff guide that we put together that is sort of the playbook that you can use in overseeing and implementing a virtual reduction in force. It has things like communication letters, messages, training materials, etc. So we're going to be sharing that information. And if you're also considering providing outplacement services, would love for you to check us out here at Careerminds. We are a virtual outplacement provider. So if you're thinking about providing outplacement as part of your severance package, please reach out and give us a look. Garrett, you want to share with everyone how to get in touch with you, a little bit about your firm, and any closing comments you have before we wrap up?
I appreciate that. So my contact information, as you can see, is on that slide. I am, as Raymond mentioned earlier, a partner at DLA Piper in our New York City office. We're a global law firm. We have, I think, 2,500 attorneys in the US or somewhere. We're about 5,000 attorneys or somewhere in that ballpark globally. And we have 70 some offices across the world. So we do everything. I'm in our labor and employment group. We've got about 100 labor and employment attorneys in the US and close to 400 globally. So we do a little bit of everything. And certainly if you have any issues, we certainly are available, and you should feel free to reach out to me.
Great. Well, hey, thanks everyone for joining. That's a wrap for today's webinar, and we appreciate some of the feedback that you've shared with us so far. We hope that you found this to be helpful. And if you do have questions, or if there was a question you asked that we weren't able to get to in today's session, feel free to reach out to myself or Garrett. You can connect with us through email, by phone. You can connect with us on LinkedIn if you'd like. So have a great rest of the day. Garrett, thank you so much. And we'll see everyone real soon. Take care.
Take care, guys.